Welcome to Health+Tech, the show where we explore the law that applies at the intersection of healthcare and technology. Your hosts, Janice Suhita, Andrea Lina, and Jonathan Ishii, are healthcare attorneys and partners at McGuireWoods LLP, a law firm of more than 1,100 attorneys with offices throughout the United States and the world.
Hi, everyone. Welcome to the Health+Tech video podcast. I'm excited to introduce you to our guest, Michael Podberesky. Michael is a partner in McGuireWoods Washington, D.C. office. Michael has an incredible background, so hopefully I will summarize it well. And we are absolutely thrilled to have him as part of McGuireWoods' team. Michael is a former federal prosecutor for the U.S. Department of Justice Civil Fraud Section. He has extensive experience in the healthcare sector, with about 70% of his work at the DOJ focused on healthcare investigations. Michael leverages his experience in Medicare, Medicaid, skilled nursing, home health, hospice, pharmaceuticals, cardiac devices, radiology, and managed care on behalf of his clients facing allegations of healthcare fraud. Prior to his service in the government, Michael was also a partner in a major international law firm where he focused on defending clients in the defense and aerospace sectors. And then Michael also served as the United States Navy as a naval flight officer, accruing over 1,000 hours of operational flight experience, including over 400 hours commanding armed combat and surveillance missions in support of Operation Enduring Freedom in Afghanistan. For his service, he was awarded the Global War on Terrorism Medal. Michael also attended Columbia Law School. So first, thank you truly for your service. I think I can speak on behalf of all of our listeners that we truly do appreciate that. And we're also excited to have you as a resource for our clients. You're definitely going to be my first call in the event any of my clients are ever the subject of healthcare investigation or litigation. So thank you again for joining, and we're excited to have you as a guest.
Thank you. Thank you for having me. It's an honor to join all three of you. It was an honor and a privilege to serve. Thank you for your kind words. And of course, welcome aboard to the three of you. The firm is very lucky to have expertise in a cutting edge area of law that is really burgeoning and relevant.
Awesome. Well, thank you again. And I'm going to start out with just our first question. With President Biden taking office, and then we've got the end of the pandemic in view, we're helping our clients think about, okay, what's next? What should they be focusing on from a compliance perspective post-pandemic? What do we see as the new administration's enforcement priorities? So can you talk about how the Biden administration may view digital health enforcement and healthcare enforcement generally?
Sure. So speaking at a 10,000 foot level, I think we're going to see increased corporate fraud enforcement. The Biden campaign issued promises along those lines to refocus on white collar enforcement. And just given the amount of money the federal government is spending right now, we've seen after past financial crises, when the government opens its coffers and spends more, there's more fraud, and in the following years, you see more fraud enforcement. Also, you see in the Biden administration's early picks to lead the SEC and the CFPB, individuals who have a reputation for being very aggressive, pro-enforcement attorneys. So I expect there to be renewed emphasis on white collar enforcement going forward. Speaking specifically about digital health, about a month ago, Acting Assistant Attorney General Boynton, in a February 17th speech to the Federal Bar Association Ketam section, provided the first clues about healthcare fraud enforcement priorities for the new administration. And of the 6 priorities he listed, I think 4 of them are relevant to the digital healthcare sector. So he listed EMR, and highlighted a couple recent significant settlements from 2020, one from 2021 and one from 2020, telehealth, cybersecurity, and then the catch-all is pandemic-related fraud, which obviously digital health companies, like every other company, many of them received COVID-related relief funds, PPP loans, and there's going to be significant resources dedicated to enforcing fraud that emanated from those programs.
Yeah, that's helpful. Well, a lot for our clients to think about, especially lots of companies taking up telemedicine or digital health very quickly in response to the pandemic and getting programs going in a matter of weeks. So it'll be interesting to kind of look back on, what that means months, maybe even a year from now as far as enforcement. So Jonathan, I think you wanted to ask some questions as well.
Yes, thank you. Hi, Michael. How are you today? My question is, since the digital health space is constantly evolving, how should providers view enforcement if they're in an area in which the underlying regulatory framework has yet to catch up?
Sure. It's a challenge to be sure. So to answer that question, I think the first thing is just first principles. When talking about the False Claims Act or even criminal false claims charges, knowledge and intent are an element of those claims. So, for instance, a False Claims Act requires the submission of a false claim with the knowledge that it's false that caused the government to pay out money. So focusing on the knowledge element, that an individual or corporation had to be aware that the claim was false, that term is defined differently for criminal and civil claims and even administrative claims. So let me talk first about criminal. Criminal requires a specific intent to defraud. You had to know what you were doing was wrong and specifically intend to do it. For the civil side, it's a lower standard, and the risk is lower. It's reckless indifference or deliberate ignorance is enough to get you crosswise with the Civil False Claims Act. And finally, on the administrative side, or a mere breach of contract action, negligence is sufficient scienter to trigger an action. But obviously the risk is less there because the damages in an administrative or contractual action are, the limit is single damages of the actual claim, and there's less risk for reputational harm. So getting back to your question, providers and digital health companies should be confident that an honest, good faith determination, even negligent ones, will not trigger criminal or civil liability. And in an environment of rapidly evolving regulatory standards, there's actually extra support for a defendant's argument that we were making a good faith effort. The regulations were constantly changing. The guidance out of OIG was constantly changing. We were doing the best we could in a fluid environment. That said, there's always the risk when it comes to issues of knowledge and scienter that there's a litigation risk involved because it's in the eye of the beholder. So while you can make a strong argument that, of course, my client was trying to make best good faith efforts in the face of a fluid regulatory environment, a prosecutor or a judge may not ultimately see it that way. And even if at the end the judge or the jury does see it that way, it may be after protracted litigation. And that litigation may be cut short by a settlement. So the risk is out there. But there is things you can do, clients can do to mitigate that risk. And my advice is to err on the side of caution, document your thought process clearly, and where prudent, confer with counsel, get an opinion letter if it's really novel and there's some risk involved. And you can also seek an opinion letter for HHS OIG about particular arrangements if warranted in a specific case. So there are things you can do as a company to mitigate those risks.
So what would you recommend if we have a client, like I was talking about earlier, that maybe got a program off the ground really quickly, and now that things have calmed down, they're kind of doing a retrospective and saying, well, maybe that one area we could have done a better job. I mean, could they work with someone like you to say, hey, help us now kind of go back and think about maybe what we could have done differently and how to protect ourselves going forward, and documenting that, or, talking through that with you?
Absolutely. They should work with folks like all of us to provide that regulatory guidance when, usually it should be done before a practice is implemented. If that's not possible or it was not done, it's never too late. And quite frankly, because of what are called the overpayment regulations, A company is obligated to do that. If they do that after the fact, if there were problems uncovered about the original practice, the company can self-disclose. The company can just issue an overpayment to the Medicare administrative contractor. There's a good chance that won't turn into a federal case. Usually when companies, do an overpayment, often that will not turn into a federal case. It's just sort of making a good faith correction. However, if a company becomes aware that there is an overpayment and fails to correct the overpayment within 60 days of becoming aware of that overpayment, that in and of itself could trigger False Claims Act liability. And you have what some might argue is a perverse situation where the original conduct may not rise to the level of a False Claims Act violation because, to go back to your example, there may have been a good faith belief that the conduct was appropriate, but at the later point, when they did become aware that the conduct was not appropriate, then they're in the overpayment situation where if they don't make an overpayment correction and pay the money that they owe, now you've triggered a separate False Claims Act liability. What's called a reverse False Claims Act liability. So it all sounds like the situations are fraught with risk and exposure. But I think if you confer with counsel, we can certainly help navigate through those situations and mitigate risk.
Yeah. So can't stick your head in the sand is part of the, you have to be paying attention to those issues for sure. Okay. Janice, you had some questions?
I've got some questions. So Michael, you've had a long and varied career in regards to various investigations, and I'm sure our viewers and listeners come from various healthcare organization backgrounds. So I think it might be helpful to describe what, in your experience, how does an investigation differ from the provider size, the provider type, things of that nature?
Sure. In theory, and according to the DOJ policy manual, there is no difference. There's one standard in practice. It applies to everyone from solo practitioner physicians all the way to the largest providers and insurance companies and manufacturers. That said, I think in practice, there are some differences that are relevant and may make distinctions in specific cases. So first, I think it's harder, going back to the knowledge requirements I talked about earlier, it's harder for a large provider or a large corporate hospital group to argue that they didn't know or they made a good faith mistake. If they have in-house counsel and a robust compliance function, the standard knew or should have known is going to be different for them than a solo practitioner or a small 3-person physician practice. Those physicians who work in that small practice can argue, look, I was practicing medicine 12 hours a day. I'm not a compliance expert. This fell through the cracks. I think that's going to carry more water with line prosecutors than if mega hospital corporation tries to make that same argument. I think another difference, and look, prosecutors are human as well. They may have more sympathy for a mom and pop shop than they will for mega corporation. Again, that's not a matter of policy. It's one standard, but let's be realistic about how things work in practice. Another important difference is on the civil enforcement side, prosecutors are tasked with maximizing return to the public fisc. That's sort of priority number one, get a good return on investment. There's almost infinite fraud on this side. The limiting factor on the enforcement side is there's only so many government resources, prosecutors, agents, auditors. So you really want to make sure, prosecutors will make sure they're triaging and focusing their efforts on cases that are going to maximize return to the public fisc. Well, in practice, that can mean if you have a solo practitioner or a small group practice that isn't particularly well funded or well resourced, and isn't going to be able to pay a large settlement, a prosecutor is less likely to dedicate a lot of resources to go after that small group practice than they will if you have the same conduct in a mega corporation that is extremely well funded and can afford to pay large damages in a False Claims Act suit. So again, not a matter of policy, but in practice, size can make a difference.
I've got another follow-up question for you. And I thought it was really interesting when you said in the beginning of our conversation that there is a lot of cutting edge and some new topics in regards to digital health. So as different providers and organizations are trying to get ready for this new normal, what would be your advice for someone to prepare in case they're ever audited, or if you feel like I've got to get my compliance program in shape here? What are some best practices that you could share with our listeners and viewers today?
Sure. Now, the folks listening to this session, they understand that there's communication with the Medicare administrative contractors. And just because they're asking questions or want to conduct an audit, that can range from fairly routine, maybe the provider was filling in the wrong bubble or clicking the wrong box. There's no real hint of fraud, to something where there is a real risk of fraud allegations. Significant mistakes were made or are alleged to have been made. And so it really runs the spectrum. I think you have to be careful. And when things start to look tricky or thorny, I think the sooner you reach out to counsel and folks who have expertise in the regulatory area or expertise prosecuting these cases, they can give you more insight into how big the risk is and how best to address and mitigate the risk. It's always good to get ahead of a problem. One, to get your arms around it. It's possible the government or the zone procurement integrity contractors have been looking into this for years, so they may have a good head start. So you want defense counsel to conduct an internal investigation where warranted and quickly get their arms around the problem, and if necessary, self-disclose and cooperate, which will help earn cooperation credit and decrease the size of any potential settlement and payment.
So Michael, if one of our clients or a healthcare provider gets a subpoena, or a civil investigative demand, what should they do?
That's a great question. If a client gets a subpoena or a civil investigative demand, first you should read it. There'll be clues within the subpoena itself about the investigation, who is leading the investigation. If it's a civil investigative demand, if it's signed by a local U.S. attorney, then DOJ has likely concluded that it's worth $10 million or less. If it's signed by the head of the civil fraud section in D.C., DOJ has likely concluded the gross amount is $10 million or higher. After reading it, you should immediately retain counsel. Do not stall on that decision. There are very tight deadlines, as few as 7 or 20 days in the case of a civil investigative demand for a response. So you want to immediately retain counsel, and counsel will want to then immediately call up the point of contact named on the subpoena to start communicating with the government and opening lines of communication to try and find out more about what this is about, how to limit the size and scope and burden of discovery requests, and start, persuading in a nuanced way. So that's my advice for what to do when served with a subpoena.
Thank you.
That is great advice, Michael. And I think that's going to take care of all of our questions and our topics for today. And I want to thank Michael for joining us. This is our first cast for Health+Tech here at McGuireWoods with the digital health team. We want to thank everyone for joining us today. We hope you come away with some insight, some really helpful information. And if you have any questions, comments, anything you want to learn more about this, please feel free to reach out to us. One, you can follow us and subscribe for our future vidcasts on the McGuireWoods YouTube page. And like everyone else, we are on social media. Michael and Andrea and Jonathan and myself, we are all on LinkedIn, and you can follow us on there. And then you can also reach us via email at the McGuireWoods website. So on behalf of the team, and we want to thank everyone for joining us, and we hope you join us for our next vidcast when you're going to learn more about digital health and technology. Thank you everybody for joining us, and we'll see you real soon.